Welcome to This Explainer. Today, we're unpacking an absolutely incredible legal collision between one of the world's most famous rappers and a New Zealand political party. We're looking at a fascinating 2017 copyright infringement case from the High Court of New Zealand that asks some really fundamental questions about music, originality, and where exactly inspiration ends and stealing begins.
Okay, let's kick things off with the iconic opening lyrics of Eminem's 2002 hit Lose Yourself. When Jeffrey Bass, Luis Resto, and Marshall Mathers, obviously better known as Eminem, composed this track, they didn't just make a song. They created a total cultural juggernaut. It was a masterpiece of tension and momentum that actually took a year and a half to perfect. The lyrics literally tell you that when you own the moment, you better never let it go. And believe me, that is a mantra Eminem's legal team takes very seriously.
But here's the big question. What happens when a political party takes that advice literally, without paying for it? We are going to explore the High Court of New Zealand's ruling when Eminem's publisher, 8 Mile Style, sued the New Zealand National Party for using a track in their election campaign that sounded suspiciously like Lose Yourself.
Section 1. The Aftermath Standard. Setting the Stakes.
Now, to really grasp the immense value of this musical property and why its owners fight so fiercely to protect it, we first have to look at the legendary label behind it, Aftermath Entertainment. Founded by hip-hop icon Dr. Dre back in '96, Aftermath is a subsidiary of Interscope. And what makes them so unique is their highly exclusive quality-over-quantity roster of heavy hitters. I mean, after Jimmy Iovine introduced Dr. Dre to Eminem in 1998, the label just rocketed to the forefront of the industry. They don't just sign anyone, they sign generational talents, like Kendrick Lamar, operating with a tiny, prestigious roster. And this label is practically synonymous with absolute sonic perfection. The Aftermath sound is legendary for clean, high-fidelity engineering and incredibly intricate layers. Because they invest so much time and skill into achieving this, like that year and a half spent just on Lose Yourself, their intellectual property is incredibly valuable. You simply don't borrow from an Aftermath track without someone noticing. So how exactly does this highly protected sound end up tangled in a political dispute? Well, let's look at the timeline. In early 2014, the New Zealand National Party was preparing for an upcoming election. They tested early animatics for a rowing-themed commercial using the actual Lose Yourself track, mostly because its steady, syncopated rhythm gave a really great sense of momentum to the rowing strokes. But instead of paying a massive licensing fee for the real thing, they ultimately used a production library sound-alike track literally titled Eminem-esque. The ads aired in August, and within days, 8 Mile Style's lawyers came knocking. Section 2. The Anatomy of a Copy. The Legal Framework.
All right, so the case goes to court, but how does a court actually prove a song is a ripoff? It's not as simple as a judge just saying, hey, these sound the same. The law requires a really rigorous structural breakdown. The judge laid out a strict 3-part legal test that the plaintiffs needed to prove to win their claim. They had to prove substantiality, objective similarity, and a causal connection. Let's look at what each of those legal hurdles actually means for a piece of music. First up, substantiality. What's fascinating here is that you don't actually have to copy the whole song, or even a large percentage of it, to break the law. You just have to appropriate the vital and essential part, or the essence, of the original. If you steal the main hook, or that signature guitar riff that makes the song recognizable, you've taken a substantial part. So it's really about quality, not quantity.
Step 2 is objective similarity, and the court brilliantly adapted a previous legal standard specifically for music. Determining reproduction doesn't involve a painstaking note-by-note textual comparison of sheet music. It involves listening. It is an oral test. As the judge adapted the rule, a copy is a copy if the ear recognizes it as one. If an ordinary listener hears it and instantly thinks of the original, you've got objective similarity.
Then we have the crucial third step, causal connection. This means proving the alleged infringer actually had access to the track. You see, you have to prove the similarity wasn't just some wild coincidence. You have to show that the creator of the copy actually appropriated the labors of the original composers. In a world with millions of songs, it is technically possible for two people to write the exact same tune by total accident, so causation definitely has to be proven. Section 3. Borrowing versus stealing. The musicology debate.
Now, instead of just giving up, the defense tried to dismantle the plaintiff's framework using the science of musicology. They basically asked, is Lose Yourself even entirely original in the first place? To make their case, the National Party brought in an expert ethnomusicologist who broke the track down. She discussed concepts like timbre, which is the unique tone color of an instrument. The defense argued that elements like timbre, standard drum patterns, and basic chord progressions are just universal building blocks in Western music. You can't own a genre's basic sounds, just like you can't own the color blue if you're a painter.
So they argued that pop and rock music is essentially made up of unoriginal, recycled building blocks. They pointed out that early British rock bands borrowed heavily from American blues. And hey, nobody sued over drum beats back then. But the plaintiffs countered this by using a legal concept called collocation. They argued that sure, while an individual drum beat or an individual chord might not be original on its own, the unique specific combination of all these elements together, that creates a highly original copyrightable work.
So the judge listened closely to both sides and deconstructed the tracks into these specific musical components: the tempo, the duple meter, the harmonic structure, the piano figures, and the drum patterns. And when broken down and compared side by side, the tracks were strikingly similar across the board. Furthermore, it came out that the original file name of the production track was literally Eminem_Abri. The undeniable inference here? The composer of Eminem-esque had the original Lose Yourself right in front of him. Ultimately, the court found that the sound-alike tracks substantially reproduced the essence of Lose Yourself. The collocation, that specific combination of musical elements, was just way too identical to be a coincidence. The court ruled that copyright infringement had indeed occurred. Eminem's publisher officially won the liability phase of the trial. Section 4. Calculating the damages. The final verdict.
With infringement officially established, the court faced a totally new problem: figuring out a price tag for a song Eminem would almost certainly never have willingly licensed to a political campaign in the first place. Because 8 Mile Style wasn't in the habit of licensing this song out for standard royalty fees, the court had to use something called the user principle. This is a legal tool used to estimate a hypothetical bargain between a willing licensor and a willing licensee. It assesses what would have reasonably been charged at the time if the defendant had just acted lawfully. It's a pretty complex judicial estimation based on market value, audience size, and exclusivity.
Now, it is incredibly important to note that the court impartially recognized the National Party itself wasn't actually acting maliciously here. The judge explicitly stated the infringement wasn't flagrant. The political party had relied on professional industry advice and purchased what they genuinely thought was a perfectly valid synchronization license from a production music library. They bought a track they were told was legally safe, which unfortunately turned out to be an unlawful copy. Because of this, the court did not award punitive additional damages against the party.
But the final compensatory penalty was still incredibly steep. Factoring in the high value of the song, its use in a nationwide political campaign, and the sheer recognizable nature of the IP, the judge ordered the National Party to pay a massive sum, 600,000 New Zealand dollars plus interest, for the unlicensed use of their musical property. As we wrap up this explainer, it leaves us with a massive, lingering question for the modern music industry. Production libraries out there are filled with tracks designed to evoke the feel of famous songs for just a fraction of the price. But this case really proved that simply changing a few notes isn't a get-out-of-jail-free card. If it sounds like a copy to the ear, it might just cost you exactly like the original. So as creators and consumers in a world of endless remixes and sound-alikes, we really have to ask, where exactly do we draw the line between musical inspiration and copyright infringement? It is definitely something to think about. Thanks for joining me on this explainer, and I'll see you next time.